Legal Aspects of Postal Money Orders, by John D. O'Malley. The postal money order, sales of which in recent years have averaged 243 million annually, looms as an unwelcome, non-negotiable fellow traveler of checks and other negotiable instruments moving through banking channels. The author reviews the cases involving the distribution of losses, most of which the government issues, that arise from fraudulently issued, stolen, or raised money orders. He concludes that postal money orders should be subject to commercial law since there is no longer any reasonable legal basis for treating their issuance as a protected sovereign function. For more than a century, the Post Office Department has issued postal money orders for the purpose of providing a cheap, immediate and safe agency for the transfer through the mails of small sums of money. 2. The continuing popularity of the system 3 is evident from the fact that in 1965 more than $42 billion were transferred by postal money orders. In view of the significant number of money orders in use today, 5, it is surprising that the legal and banking communities have given only scant consideration to the legal nature of the instrument itself and to a determination of who will bear the loss resulting from fraudulent issue, forgery, or alteration. 6 While a new encounter with a potential loss from a bad money order can be expected to invite out of the dusty bookshelves all of the decisions treating loss distribution, a look at the existing state of the law will produce a somewhat confusing, if not alarming, picture. The statutes establishing the postal money order system were patterned, with some modification, after those adopted in 1848 in England. The actual form in which postal money orders are written has changed several times since their inception, except that all forms have included the name of the purchaser and the amount payable. The earliest forms were drawn by the postmaster at the place of purchase on the post office closest to the place where the purchaser, remitter, intended to send the money order. The payee was not named in the money order itself, but his name was contained in the application form forwarded to the drawee post office. 2. It was contemplated that the application form would arrive at the drawee post office before the holder requested payment, as this was the only method of determining who was entitled to receive the money. In later forms the payee was named, as were the drawer and drawee post offices. The form in use today contains the stamped name of the issuing post office, the issuer's initials, and the name of the payee, but the drawee is omitted. Presumably, the unnamed drawee is now the Post Office Department instead of any local post office. Negotiability of postal money orders. A review of the meager authority on postal money orders will produce but one definite conclusion, a negative one. A postal money order is not a negotiable instrument. For the obligations undertaken by the government in the issuance of postal money orders and their negotiability are severely restricted by statute. In commenting upon the absence of freedom of circulation and of an unconditional promise to pay, the court in Bologna v. United States pointed out that, 1. The cashing of a money order cannot, under ordinary circumstances, be made in advance of the receipt of the corresponding advice. 2. More than one endorsement of a money order invalidates it. 3. After an order has once been paid by whomsoever presented, the department will not be further liable. 4. Payment of orders will be withheld under a variety of circumstances. 17 And Judge Brewer of the Circuit Court for Colorado, later Associate Justice of the Supreme Court of the United States, stated in United States v. Stockgrowers National Bank that, it is undoubtedly true, as settled by the case of Cook v. U.S., 91 U.S. 389, that when the government descends from its position as sovereign and deals in negotiable paper, it subjects itself to the ordinary rules controlling negotiable paper the same as any individual. But these post office orders are not negotiable paper, they are orders drawn by one postmaster upon another, payable to a particular person not named in the order itself, unknown save as to the particular parties to the transaction, the two postmasters and the party who obtains them, so that the protection which the rules applicable to negotiable paper would lay around many transactions do not avail the defendant in this case. 19. However, the unity of opinion concerning the non-negotiable character of a postal money order 20 has not produced results exhibiting perfect logical consistency. For example, although he will not permit the purchaser of a postal money order to stop payment to without surrendering the item. 22 The Postmaster General can, on his own initiative, stop payment of money orders in the possession of parties who are, in his judgment, conducting a lottery through the mails. 23. The reverse side of the money order form in current use contains a statement giving notice to the payee and his endorsee that only one endorsement is authorized by law. 2 However, the statute does permit payment to be made to the holder of a money order containing more than one endorsement if the holder can establish the validity of his title. 25 In Lewin v. United States, 26 the plaintiff held 95 money orders, with a value of $8,344, which he had purchased as second endorsee while residing in the Philippine Islands. Since all the money orders bore a second endorsement, the Postmaster General refused to make payment unless the holder produced evidence of the validity of the endorsements and of his ownership. Lewin was unable to locate or even identify any of the payees or emitters named in the money orders, and the Court of Claims, in upholding the position of the Postmaster General, stated, "The instruments involved in this case are not negotiable instruments and are not therefore governed by the laws applicable to commercial paper. They are specialties called money orders and are governed by the postal laws. In order for the plaintiff to receive payment, he must comply with the procedure required by those laws. In order to obtain payment on these money orders, he must make proof of the genuineness of the endorsements as the Postmaster General may require. The mere fact that the plaintiff is a holder for value is not sufficient. The issue is whether the plaintiff has complied with the statutory requirements. We hold that he has not met these requirements and that in refusing payment, the Postmaster General acted neither arbitrarily nor capriciously. 27. The Lewin case is considered here merely to illustrate the application of one of the statutory provisions regulating postal money orders to 8 and to demonstrate one of the effects of the non-negotiable nature of such orders. However, it would seem that for the government to require the stated proof of ownership in the complete absence of any evidence of the holder's bad faith or an adverse claim, such as a request by the purchaser, payee, or first endorsee for replacement of a lost or forged money order, is clearly unreasonable in light of current commercial practices in comparable situations. Rather than completely denying payment in such cases, 29 the Postmaster General could honor the holder's claim upon the submission of an affidavit of title and a corporate sureties bond indemnifying the government and any other party for any loss which might be sustained as a result of an improper payment. If that procedure were followed, there would be no undue burden of proof placed upon good faith purchasers of money orders containing more than one endorsement, and the parties involved would be afforded sufficient protection from loss. Fraudulently issued money orders. Probably the most troublesome cases concerning postal money orders are those involving postal employees who issue money orders to innocent persons as part of an embezzlement scheme. Indeed, the first case to consider loss distribution in matters of bad postal money orders involved such a situation. In United States v. Stock Growers National Bank, 3 inches the postmaster at Lewiston, Idaho, issued money orders drawn on the post office at Pueblo, Colorado, without making payment for them. He then sent the orders to the defendant bank with directions to deposit the proceeds to the account of one J.G. Wilson, a fictitious name assumed by the postmaster. Shortly after the bank had received payment from the post office in Pueblo, the postmaster withdrew most of the proceeds. In refusing to accede to the government's demand for repayment, the bank grounded its defense on 2 well-established principles, namely, that, 1. A principal is bound by an agent's wrongful acts committed within the scope of the agent's apparent authority, and, 2. A final payment is irrevocable. The court rejected the first contention, stating that as a general principle of agency it does not apply to the government, and that as a principle of the law merchant it does not apply to postal money orders, since they are not negotiable instruments. 2. The court dismissed any consideration of the harshness of its position with the comment that the general weal of the public requires that the individual and not the government should bear the burden of the conduct of the government's agent. S. However, as its basis for holding the bank liable, the court considered that payment of the money orders by the post office at Pueblo was only provisional, since a final determination of the validity of the money orders and their issuance rested with the post office department in Washington. for the conclusion does not seem supportable. However, in view of the fact that the money orders were actually drawn on the post office at Pueblo, instead of the post office department, and that the former office had authority to pay them. 5. But the more unusual aspect of the decision is that by holding final payment not to have taken place, the court gave tacit approval to the bank's contention that the concept of finality of payment, as established by the law merchant, S6 is applicable to postal money orders. Conceivably, then, if payment had been held to be final, the government would not have been able to shift its loss to the collecting bank. 37. The possibility of an early application of the law merchant to postal money orders was effectively precluded, however, by the next case to treat fraudulently issued money orders, Bologna v. United States. 8. In that case, one Marone, who was a banker as well as the clerk in charge of a postal substation, issued to the appellants as payees 128 money orders with a total value of $12,800. These money orders, which had been given in payment of sums due the appellants for foreign currency surrendered to Marone, as banker, for conversion into United States currency, were presented to and paid by the Brooklyn Post Office. In ruling for the government, whose case was presented by the then Assistant United States Attorney Felix Frankfurter, and in refusing to apply the rules of the law merchant by which the principal would be bound by the agent's actions in issuing commercial paper, the court stated, in the establishment and operation of the money order system the government exercises a governmental power for the public benefit. It serves the public by furnishing a safe and cheap method for transmitting small sums of money. It carries on the system not for gain, but to supply a public need. It does not engage in business, but stands in its position of sovereignty. Consequently, the principles which govern commercial transactions between individuals have little application in this case. It follows as a corollary to the conclusion that the government in issuing money orders exercises a governmental function and does not engage in a commercial transaction that money orders are not negotiable instruments subject to the defenses permitted by the law merchant to bona fide holders for value. They stand in marked contrast to notes or similar obligations which the government might issue to obtain money for its own use and upon which it might incur all the responsibilities of a private person. 39. It is not easy to assess the correctness of the legal judgments in the stock growers and Bologna cases, especially in view of the harsh consequences visited upon innocent parties in the wake of some imponderables of public policy. Standing together, the cases provide formidable authority for the proposition that in the issuance of postal money orders the government acts in its sovereign capacity, and the principles of the law merchant, whether concerned with the apparent authority of an agent or finality of payment, are not applicable. A subsequent discussion will consider the validity of this proposition in view of current practices. 0. Another issue in cases involving postal money orders fraudulently issued by postal agents is whether the negligence of the government in failing to discover the wrongdoing will operate as a bar to recovery. The issue was not raised in the cases already considered, except inferentially in United States v. Bologna. 41. In offering a defense of good faith, 42. Bologna alleged that the Post Office Department, through an inspector, had conducted an investigation of Marone's business dealings, including the issuance of a large number of money orders to Bologna, and had assured the latter that the transactions were in every respect right and proper. He also alleged that some time after the investigation he asked a postal auditor if Marone's practice in issuing money orders in payment of his own banking obligations was permissible, and he received a reply that there was no reason why Marone could not do it. Although the court, in sustaining the demurrer, ruled that such evidence of good faith would present no defense to the government's action, there is no indication that it was asserted that the same evidence would demonstrate negligence on the part of the government. The issue of negligence was properly raised in United States v. Citizens and Southern Natal Bank, 43, which involved a suit by the government to recover about $13,000 paid on 130 postal money orders issued for insufficient consideration by a post office clerk. The misappropriations took place over a period of 8 months, during which the money orders were sent to the defendant bank, to which they were made payable, for deposit to the clerk's account on the application forms retained at the issuing post office. The clerk showed various parties as the purchasers and indicated that the orders were for sums ranging from $1 to $6, with an aggregate principal amount of only $281.38. Not only did numerous other discrepancies and circumstances exist which should have alerted the postmaster to the defalcations, 44, but after the fraud was discovered a delayed notice was given to the bank. In a trial without jury, the court concluded that the government was guilty of such flagrant and continuing negligence, 45, in the supervision of its employee and in the discovery and giving notice of the fraud as to constitute a bar to recovery. It was without any apparent twinge of remorse that the court distinguished prior cases 46 and blandly ignored those which hold that the government is not chargeable with the knowledge or negligence of its employees in the performance of governmental functions, 47, even in cases involving negotiable instruments. 48. In departing from the traditional view of governmental immunity, the court fastened its decision to those cases which have enunciated the principle that any defense which can be asserted against an ordinary party can be urged against the government as plaintiff, 49, since pleading a defense, such as negligence, is not the same as seeking to recover damages from the government in a suit based upon the negligence of its employees. In adopting this view, the court reasoned that, if the plaintiff were allowed to recover, it would mean that a party whose agents and employees were negligent could recover from a defendant who was not even charged with fault. It is perfectly clear that if the plaintiff were an ordinary citizen, the plaintiff could not recover. Likewise, the sovereign as plaintiff should not recover in this case. This is not a case of the sovereign being harassed by an action being brought by one of its subjects, but is a case of the sovereign coming into court and asking for justice. Degrees. While United States v. Citizens and Southern Natal Bank is susceptible to attack from the standpoint of precedent, the result is so clearly demanded by the facts that it is doubtful that many legal voices of dissent will be heard to challenge the decision. However, since the court cut such a wide swath in enumerating the acts which collectively, rather than individually, constituted sufficient negligence to preclude recovery, 51, there will be difficulty in applying the decision to cases with similar fact situations. Stolen blank money orders. As could be expected, the theft of blank money orders from post offices, and their subsequent completion and transfer to innocent parties, is not an unusual occurrence. 2 Such a series of events was involved in United States v. Northwestern Natal Bank and Trust Co. 53. In that case, the post office at Mississippi City, Mississippi was burglarized and the thief stole both blank money orders and the rubber stamps used to validate them. 12 of the money orders were completed in usual form by the thief for $100 each, drawn on the post office at Minneapolis, Minnesota, payable to a fictitious payee. Though the defendant bank cashed the money orders, it did so only after one of its clerks telephoned a branch post office and received assurance from an unidentified postal clerk that the described money orders were genuine. The postal clerk had overlooked the fact that they were listed as stolen in a postal bulletin on file at the branch. When the bank presented the money orders to the main Minneapolis post office for payment, the postal employees again failed to detect them as stolen, and they were therefore honored. Despite the genuine but unauthorized form of execution and the failure of the postal employees to identify the money orders as stolen, judgment was rendered for the government. In holding the bank liable for the government's loss, the district court based its decision upon the equitable right to recover money paid through mistake of fact, 54, rather than on the statutory grounds relied upon in the Stock Growers and Bologna cases. 5 Although the court recognized that by holding the bank responsible in such a case it might impair the mobility of these instruments in business transactions, 56, since banks could not rely upon the integrity of money orders, although accepted and cashed by the government, 57, it nevertheless rejected the bank's argument that the concept of finality of payment, as embodied in the law merchant and developed through the various ramifications of the doctrine of Price v. Neal, 58, was applicable also to postal money orders. 59 The court concluded that the equitable doctrine of permitting a recovery where there has been an unjust enrichment should have greater weight than the doctrine enunciated in Price v. Neal. 60. Doctrine of ML stake. The court in the Northwestern Natal Bank case not only devoted as little time to considering the commercial aspects of postal money orders as Alexander gave to the Gordian knot, but it also incorrectly applied the doctrine of mistake. Although the equitable rule that a mistaken payment can be recovered, even though negligence surrounds the mistake, 61 is not open to serious question, it is not absolute. The rule is inapplicable in any situation where an obvious injustice would be effected. Ordinarily, restitution results in no loss to the recipient of a payment made through mistake, because the party was entitled to nothing in the first place. But where the recipient has changed his position in reliance upon the payer's mistake, justice does not dictate that the benefit be returned, since it would result in a loss to the recipient. 62 In the case at hand. 3. It is true that in point of time the bank cashed the money orders before it received payment from the post office, and there was, therefore, no change in position in reliance upon the payment itself. But the cashing was in reliance upon an assurance from a postal clerk that the money orders were valid. 64 Thus, there was a change in position based upon the government's mistake in characterizing the instruments as genuine, and the existing equities would not require a return of the money received by the bank. Although restitution is an equitable device used to achieve justice, somewhere along an intangible line the concrete case becomes an abstraction, and an absolute or rigid rule emerges from what originally was a malleable rule of equity. However, rules of equity were never intended to develop myopic limitations simply because of age. The change in position which will terminate the right to recover a mistaken payment does not necessarily have to follow payment. In a proper case, it could precede it. Banks as agents for collection. The position occupied by a bank in the handling of postal money orders normally is that of an agent acting for a principal, rather than that of a purchaser of the instrument, and this appears to be the case whether the postal order is deposited by a customer for credit to his account or is cashed over the counter. 65 A bank could, however, be the purchaser or true owner of the instrument when, for example, it is taken in payment of a loan or for services or goods. In the application of principles of agency, once an agent has performed his obligation in good faith, he is not liable to the third party with whom he deals on behalf of a principal. 66 Thus, if a bank, as agent, receives a payment by mistake and in good faith pays the money to its principal or customer, the bank incurs no liability to the third party. This point was ably developed, by way of dictum, by Judge Brewer in the Stockgrowers Natal Bank case, 68, but for 75 years it did not receive the attention it deserved. Then it was resurrected in a case involving raised money orders. Raised money orders in the United States v. Cambridge Trust Co., 6 inches. The latest reported case to treat postal money orders. 1. Ralph Porter paid for various electrical supplies and appliances purchased from the EMF electric supply company with postal money orders which he had raised approximately $90 each. 70 The money orders, payable to himself, were specially endorsed to the supply company which, in turn, restrictively endorsed 699 of them for deposit to its account at the Cambridge Trust Company. The face amount of each order was paid by the Federal Reserve Bank of Boston. When the Cambridge Trust Company received notice from the government that the orders were raised, 71, the bank had already paid the entire proceeds to the supply company. In affirming the district court's entry of summary judgment against the government, the Court of Appeals relied solely upon the application of rules of agency. In summarizing the court's views, Judge Woodbury stated, "In this situation there is no need to consider whether postal money orders are to be treated as negotiable instruments or non-negotiable instruments when in fact being negotiable but once, they fit precisely into neither category. The bank is entitled to the benefit of the old and well-established principle, applicable alike in cases involving negotiable instruments and in those which do not, that a known agent who receives money paid to him by mistake is protected from a liability if innocently and in good faith he has paid the money over to his principal before receipt of notice of the payer's mistake." 73. Postal money orders and the law merchant. The more recent cases involving postal money orders 74 have been decided correctly but upon issues which have permitted the courts to skirt conveniently around the deeper issue, that is, Whether the sale of postal money orders today is a commercial transaction subject to the rules of the law Merchant 75, especially finality of payment, or whether it is still a function of sovereignty. But the right question will eventually have to be raised, and the issue joined where it ought to be, namely, whether or not the public policy evident in the earlier cases 76 makes sense today. However much validity there once may have been to the contention that the government is exercising a sovereign function in selling money orders, that contention is now open to serious doubt. If the sale of postal money orders is in direct competition with those sold by private enterprise, or if the government has for its own benefit injected them into the normal stream of commerce, then it would seem only logical to conclude that their issuance is no more an action of sovereign capacity than is the issuance of checks, bonds, or notes. 77. When the postal money order system was inaugurated in 1864,78, it may have been a unique service to provide those persons who did not have checking accounts with a substitute for money. Since that time, however, most banks and several non-banking establishments have also entered the money order market, and the service has come to assume all the aspects of a commercial venture. A representative comparison of the fees charged for money orders will reveal that the government charges not only as much as its competitors, but usually more. Thus, it is no longer true that the postal money order system is carried on not for gain, but to supply a public need. 83. It is in direct competition with bank money orders, private money orders, and numerous purchased check devices such as cashier's checks, registered checks, and traveler's checks, all of which are subject to the laws governing commercial transactions. Even though at one time all postal money orders were payable only at post office branches, they have long been collected through banking channels, as is evident from the cases already considered. And to promote such a collection procedure, which obviously inures solely to the benefit of the government, bank stamps are not treated as endorsements. 84. But not only has the government encouraged the introduction of postal money orders into the private commercial world, it has practically ensured it since 1951 by providing during that year that Federal Reserve banks may pay money orders. 85. The result of that provision is that now very few money orders are cashed by post offices. During the 5-year period from 1961 through 1965, the average annual sales of postal money orders amounted to 243,533,600 with a value of 4,771,907,270.86 during the same period, an average of 241,607,800, or 99% of the money orders issued with a value of $4,671,212,000, or 97.9%, were handled not by post offices but by commercial banks and were paid by Federal Reserve banks. 87. Thus, substantially all postal money orders have been deliberately injected into the usual stream of commerce by the government for its own benefit, and it is clearly untenable, if not an atomic attack upon common sense, to deny the relevance to postal money orders of the commercial law which governs the rights of all other parties dealing with negotiable and non-negotiable paper. 88. To hold that postal money orders are subject to commercial law may, like all categorizations, have the attraction of simplicity, but it is not without the usual complications. In cases involving fraudulently issued money orders, the government could not refuse payment or shift its loss to others, since the acts of its authorized but defaulting agent would be imputed to it. But where a forged endorsement is involved, any payment could be recovered, and a bank or other collecting agent would not be relieved of liability. Of greater importance in terms of loss frequency, however, would be the consequences of final payment of a counterfeit, stolen and completed, or altered money order. In such cases, the government could not recover from a good faith holder for value or from one who had in good faith changed his position in reliance upon payment. But when would final payment take place? If, by agreement, the Federal Reserve banks have the right to make a payment which is not conditional, then when a cash payment is made or a provisional credit becomes irreversible, payment would be final. On the other hand, If actual payment can be made only by the Post Office Department in Washington, through the audit division to which all money orders are now sent, then its cash payment, final settlement, or retention of a money order beyond a reasonable period of time without notice of dishonor would constitute final payment. 89. Conclusion. In the early cases involving the fraudulent issuance of postal money orders and the theft of blank ones, the courts, in relieving the government of any loss, made a drastic and intellectually unwarranted leap from a perfectly proper legal concern for the public policy interest in governmental functions to a blatant disregard for justice and reason. If the courts in the future decide that legal improvement is to be obtained only through the loyal preservation of the past, then to maintain the direction of the older cases they will have to hammer out new theories. Clearly the old ones no longer have any persuasive force. Since postal money orders are sold in direct competition with private enterprise and are injected into the normal stream of commerce, their sale cannot be treated as a function of government, but rather must be viewed as a commercial transaction at the same level as the government's issuance of checks, bonds, or notes. They are, therefore, subject to the law merchant as expressed in the federal common law or the Uniform Commercial Code degrees. Such a conclusion should not provide any anxious moments for those sensitive spirits among us who are in perpetual agony about the rising costs of government. Any additional losses to the government should be used as a factor in determining the fees charged for money orders, although high enough now to produce a substantial profit in any efficient organization. 9. Thereby achieving a relatively wide distribution of loss by spreading it thinly among all postal order purchasers.